proceed with your motion.
Your Honor, the state has two motions they would like to put forward. Would you like a copy of them?
Sure. And I take it opposing counsel seen them already, is that correct?
Yes, Your Honor, they should have a copy.
All right.
The first matter is that the state wishes to exclude all mention of Gloria Streeter's acquittal charge. We believe that it is not logically relevant, and even if it is logically relevant, it is outweighed, its probative value is outweighed by the danger of unfair prejudice that it would give to her. That it would give. The probative value is very minimal of this, then it might mislead the jury. The jury may believe that the facts of this case are the same as the facts of the other case, and that because she got acquitted on her charge, that the defendant in this case should therefore get acquitted as his charge, and they'll be forced to guess at facts that they don't have in front of them. At the same time, it would also confuse the jury, as they would be focusing on what may have happened that made her get acquitted, since they don't know the reason why she was acquitted. They don't know if it was on the merits or if it was a technicality.
Okay, all right, response.
Your Honor, under 401 relevancy, this is completely relevant under 401 because it makes the fact of premeditation more probable. There isn't a dispute about who shot Dr. Streeter. We know that. The issue here is premeditation. And the state's case isn't that Mr. Dean decided on his own to kill Dr. Streeter. The state's case is that he wanted to because of his conversation with Mrs. Streeter. Therefore, her actions are relevant. The 403 balancing test, Your Honor. There is probative value for the defense in allowing evidence of Mrs. Streeter's acquittal because it's not unfairly prejudicial. The charges were different. This is a charge of murder and not conspiracy, Your Honor. For example, if there was a dispute as to who pulled the trigger, the other person's acquittal or conviction would be prejudicial in some way, but that isn't an issue here. There is no dispute that Mr. Dean shot Mr. Streeter. Whether or not he premeditated his need is to be proved by the state today, beyond a reasonable doubt.
All right. I'm going to grant the motion.
Thank you, Your Honor.
Any testimony about Ms. Streeter's acquittal on charges with conspiracy to commit murder, all right, will not be introduced or listed in any of the evidence in any way. Does everyone understand that?
The state also has one more motion.
Okay.
The state wishes to exclude any mention of Ms. Dallas Streeter's delusional thinking. We say that this is also unfairly prejudicial to Ms. Dallas Streeter. There is no evidence that will be presented today to define for the jury what delusional thinking actually is as a medical term. There's also no evidence presented that shows if she has, and to what extent, if she did have any symptoms of delusional thinking. Her therapist will not be on the stand, and so the jury will be left to guess and assume what this means and how much it affects, if it does affect Ms. Dallas Streeter at all.
Response.
Your Honor, with regards to that issue particularly, for the lack of medical evidence to support or explain their witnesses' delusional thinking, even if there was extrinsic evidence available, that would still be a collateral issue in this matter. But that doesn't mean that the evidence shouldn't be allowed in, because it goes directly to Ms. Dallas's credibility. And I believe in opposing counsel's motion, they argued that there's no probative value because there's no difference between the testimony of their witness and our witness. However, Your Honor, we have three versions of the same conversation, and therefore anything that goes to the credibility of Ms. Dallas Streeter is going to be of highly probative value in this case. It's also not unfairly prejudicial because if the state's case is that their witness's testimony is the same as our witness's testimony, letting in the issue of delusional thinking has no prejudicial value because the testimony, according to the state's motion, is still going to be consistent. Therefore, we would ask that you deny that aspect of the state's motion to exclude.
Wouldn't her delusional thinking also go to her ability to remember and recollect what she supposedly observed?
Well, because we don't have her therapist on the stand or anyone who can speak to the symptoms, the jury doesn't know
Who
if.
cares about her symptoms?
Excuse me?
Who cares about her symptoms? Either she was delusional and reporting what she thought she had heard, or she wasn't. What does symptoms have to do with that? I mean, doesn't it go directly to her ability to remember and recollect and to perceive? You know, they say one's perception is one's reality, but if one's perception is not reality, sounds like to me that makes it pretty relevant as to whether or not, you know, they were being delusional or actually observing what really occurred. You want me to exclude that?
Without any evidence to say how badly she may be affected by this, the jury doesn't know if it's a extremely minor,
Well, tell me
has an
this,
extremely
counsel.
minor effect on her.
Tell me this, what are the fundamental elements necessary for a witness to be competent to testify at trial?
They have to have first-hand knowledge of.
First-hand knowledge, that's observation, right? And what else?
They have to be competent to relate.
Competent meaning what?
They must be able to relate to the jury what they saw in a accurate
Okay,
manner.
yeah, what they saw, so we got an issue here of whether or not she's being delusional in what she observed. Don't you think that's really highly relevant and pertinent to this case?
I agree that it's relevant and pertinent, but I also would say that without any framework of how this affects her and to what extent, it's a high danger of being very prejudicial to the jury because it has that negative connotation to it.
Well, to me, it sounds like I would be in high danger of being reversed on appeal if I kept that out, so that's denied. What else you got?
That's it, Your Honor. We have no
Okay,
further
anything else?
questions.
All right, so the trial was supposed to start at 6 o'clock, so it's about 1:45.
Your Honor, I
We're
apologize.
still waiting for the jurors, right? Are the jurors here?
Yes, and I apologize for interrupting you. The defense also has two motions that we'd like to be heard as well,
Oh, you
please.
do?
Would that be okay to proceed?
Sure, go right ahead.
Your Honor, since this is a criminal case involving the accidental death of Dr. Hippocrates Streeter, the evidence at issue here in our motion is a photo to exclude a photo of Dr. Streeter's right arm. And our objection is relevance under the 403 Federal Rules of Evidence. Your Honor, you should exclude the photograph of Dr. Hippocrates Streeter's right arm from any testimony references or other documents relating to it for the following three reasons. First, the photograph is not relevant to prove any issue in the case. It's irrelevant under the Federal Rule of Evidence 401 because it doesn't make any fact of consequence more probable or less probable in this case. There's no conclusive evidence as to how the markings on Dr. Streeter's arm occurred, and therefore the theory behind any writing on Dr. Streeter's arm is just speculation. Further, even if Dr. Streeter did scrawl the word murder on his own arm, this in itself does not make it any more or less probable that the defendant killed him with any premeditation or intent. It's simply speculation. Secondly, Your Honor, even if the court deems the photo to be relevant, it is inadmissible under the Federal Rule of Evidence 403 because its probative value, if any, is substantially outweighed by the unfair prejudice that it will cause our defendant.
What unfair prejudice is that?
Because the photo of his arm will infer to the jury without any foundation that the defendant killed Dr. Streeter. And so any speculation concerning the markings that occurred or what the victim thought happened unfairly implies that the defendant murdered him. And without any conclusive evidence to support this inference, the photo is highly and unfairly prejudicial to Henry Dean. Furthermore, even if the victim did believe that he was murdered, managed to plant the message somehow, any probative value is substantially outweighed by the fact that the victim may not have been in a position to determine what exactly had happened. So, Your Honor, the defense requests that this court enter an order granting a motion in limine to exclude the photo of Dr. Streeter's arm and any reference through testimony or other evidence.
Response?
Thank you.
Your Honor, the state would say that this is very relevant because it goes to prove whether this was an intentional killing or just an accident. And
How?
Because if the victim was to write it on his arm, it shows that the victim believes, the only other person who is at the scene believes that this was an intentional killing and not an accident. And since premeditation is one of the elements that must be proven, this goes directly to that.
How do you know,
prove that.
how do you know the victim wrote it on his arm?
There's many evidence. There's a lot of evidence. The victim is left-handed, and he also had a deep cut in his left thumb. The word murder was written in his own blood on his arm, and he was also conscious, or he was at least alive, about 20 to 30 minutes after the murder occurred, while he would have been being driven to the hospital, so he would have had the chance to do that to himself. I would also like to say that the probative value here is very, very high. Since he was the only other person at the scene of the crime, and it goes directly to the element of premeditation, goes directly to the element of premeditation, and that's the only other witness that was actually at the scene that could have saw what had happened. No other witness has that kind of insight to bring a fact to this case, and the possible danger of unfair prejudice is low because the victim's face is cropped out, most of his body is covered up, you can barely see the wound on his chest. So the gruesome factor and the fact that you would not see the face of the deceased would lower the emotional response that the jury may have at seeing such an image and allow them to focus solely on the arm and the words murder.
All right. So, since the victim and the defendant are the only two people involved in this, you're telling me it doesn't make sense that the defendant would have written murder on the victim's arm, right?
There's no evidence that the defendant would have written murder on the victim's arm. There's no other person at the scene of the crime that murder could be attributed to.
So that could be a dying declaration almost.
Yes, sir. That says how we believe that this would not even be hearsay if it was to come in.
Would it? Yeah, it would be hearsay, but certainly that would be an exception to hearsay, right?
Yes, Your Honor.
Okay. All right. Anything else on that point?
Yes, Your Honor. There was no evidence that the word murder actually existed at any point in time up until he was in the hospital. There was nobody, the detective didn't see the word murder written into his arm, and Gator Dean himself had stated that there was nothing written on the arm of Dr. Streeter. The intake physician that examined Dr. Streeter was a friend of his, and so we don't know actually who placed that word on Dr. Streeter's arm. And I would argue that it is very, very prejudicial to the defendant, as we would only be speculating at this point in time. We cannot yet ask Dr. Streeter to testify, unfortunately, because he is deceased. And any photo that the jury sees with the word murder, they would automatically react with an emotional response and correlate the inference that the defendant did indeed kill Dr. Streeter.
All right. Your motion is denied. Will be admitted. You have anything else?
Yes, Your Honor, just one more motion.
All right.
The defense asks that you grant our motion in limine to exclude any evidence, testimony, or any other reference to the fact of the defendant burning carpet in his cabin after the fact of the incident. I have a copy of my motion. Would you like
Yeah,
to
sure. Let me
see
see it.
Your Honor, may I approach?
You sure may. Thank you.
Your Honor, just to give you some background information, the issue in this case is not who killed Dr. Streeter. We already know that that's not a secret here, and that's not something that we're trying to figure out. The issue here is premeditation and intent, and mainly whether the defendant, with the doctor's wife, planned to kill the victim. After the shooting took place, in which the defendant drove the victim to the hospital, the defendant went back to his cabin, the detective arrived and saw him burning carpet in his cabin, which had a stained red substance that he was burning. It should be excluded under Federal Rule of Evidence 401 because the burning of a carpet with a red substance doesn't help to prove any material, doesn't help to make a fact more or less probable in this case. We already know that Dr. Streeter was shot in the woods, and we know that the defendant did that. There's no issue here. So any value as to what he does when he goes back to his house is just, it just doesn't make a fact more or less probable. The second issue is that even if you find it to be irrelevant under 403, any probative value it has is substantially outweighed by its unfair prejudice, because the idea of the defendant going back to his cabin and burning some carpet with a red substance which looks like blood will give the inference to the jury that he's trying to hide something or cover something up. But those are just not issues that we have in this case. The defendant went with the doctor, shot the doctor, which is admitted, and then he took him to the hospital, and therefore there's no issue that that relates to for him to be of any probative value.
How do we know where he was shot?
Because all the witnesses in this case, I believe his wife will testify, that they went to the woods with the defendant and the victim.
Was she there?
No, Your Honor, she was
How
not
did
there.
she know he was shot there?
Well, Your Honor, I don't think that's an issue of dispute in this case or part of the state's theory as I understand it. But even if it was, the issue here is premeditation, because we're not trying to figure out who shot him. We already know that. If the issue is premeditation, and what the state's theory is that he premeditated with the victim's wife to kill him, there's still no relevance to him burning carpet with stained red substance after the fact, because why would he be trying to hide something if he'd already done the act?
Let's see if the state can answer that question. What says the state?
The state has never stipulated that this killing happened in the woods, and because the detectives found zero evidence that it did happen in the refuge, the fact that there is some evidence that it may have happened in the cabin makes that evidence very probative, has a high probative value for us. There's little danger of unfair prejudice to the defendant, because the defendant will be able to get on the stand and explain why he was burning the red carpet with the red blood stain.
How do you know that? Maybe he might decide not to testify.
That is true, Your Honor. The detective will also be on the stand, and the defense will have a chance to cross the detective, who is the one who will have seen the defendant burning this carpet, and they'll get to cross her to give the jury a framework of what she actually saw and what kind of inferences we can make from what she observed.
All right.
Furthermore, Your Honor, the defendant's actions before and after the killing occurred also go to whether this was an accident or if this was premeditated. If his actions don't line up with the physical evidence, and if his actions don't line up with how you would, the jury may believe someone who did just kill someone through an accident, that shows that the defendant might not be telling the truth, and this is instead his story is a cover-up story, as opposed to factually true details of what happened. And this evidence of how he acted when the detective went to the cabin goes completely to that theory.
All right, we can't try this case in a vacuum. The jury can hear the evidence and they can assign whatever weight they want to assign to it. So I'm going to deny that motion. Anything else?
Nothing from us, Your Honor.
Okay. All right, so it's about 5 to 6. Do we have all